I am Vanita Patnaik. I am a faculty at the National University of Juridical Sciences, and today I will be speaking on bankruptcy fraud. Bankruptcy fraud is a white collar crime. Usually, bankruptcy fraud involves the concealment of assets. The most common bankruptcy fraud is concealment of assets, false oaths, and bribery. The law recognizes 9 types of fault, all of which require proof of knowingly and fraudulently doing something in a bankruptcy context, namely concealing of property of the debtor's asset from the court, making a false oath, committing perjury, presenting a false proof of claim against a debtor's estate, receiving property from the debtor's estate with the intent to circumvent the bankruptcy proceedings, taking a kickback for the forbearing of a claim against a debtor while acting as an agent, or transferring or concealing the property of an individual debtor or corporation, cooking of books to hide debtors' financial affairs, and withholding property or financial affairs from the knowledge of the insolvency practitioner. Out of these main three types of bankruptcy fraud are concealment of assets is the most common because it is the simplest to do and also the easiest to do. Accidentally, beyond simply misrepresenting information, a bankruptcy fraudster is who commits concealment of assets and can also hide assets. Moving funds into offshore accounts is a classic example, and doing so most assuredly violates the fraud laws. But doing so would also hide such assets from any sort of declaration process, not the least because it would remove those assets from the reporting of individuals' financial statements. The bankruptcy claimant would also attempt to give his or her funds to family members or friends so that those individuals could hold on to those assets until the bankruptcy claim has been completed, and then the claimant could receive those assets back from his friends or family. In any bankruptcy proceeding, the party declaring bankruptcy must list all assets available to him, her, or it, such that the bankruptcy proceedings can accurately judge how best to deal with those assets. Creditors can only liquidate those assets listed by the debtor. Hence, if the debtor does not reveal such certain assets, the outstanding debt cannot utilize the concealed property towards the satisfaction of claims. To further conceal assets, the businesses or individuals may transfer these unrevealed assets to friends, relatives, or associates so that the assets cannot be located. This type of fraud raises the risk and cost associated with lending. The proper operation of the bankruptcy system depends upon the honesty of the debtor's complete financial disclosure by the debtor is required, and those who seek the shelter of bankruptcy code must not only play fast and loose with the assets or with the reality of their affairs. Indeed, the bankruptcy code is designed to ensure the complete and truthful reliable information is put forward at the outset of the proceedings so that the decisions can be made by the parties in the interest based on fact rather than fiction. Debtor honesty is a fundamental requirement of bankruptcy laws. Dishonesty among debtors in failing to completely disclose their financial affairs undermines the civil bankruptcy system, and certain dishonest acts committed by the debtors may even constitute a bankruptcy crime. The criminal bankruptcy provisions are not concerned with individual loss or even whether certain acts are caused anyone any particular harm. Rather, the statutes establishing the bankruptcy crime seek to prevent and redress abuses of bankruptcy system. To this end, the bankruptcy regulations criminalize voluntary, intentional, and fraudulent abuse. In particular, the code criminalizes a debtor's knowing and fraudulent attempt to conceal from a bankruptcy adjudicating authority or other officer of the court any property belonging to the estate of a debtor. The penalty for a violation of the provisions can be a fine or a term of imprisonment of more than 5 years if or both. The extent by which the courts are willing to extend the reach of the code and thus criminalize to an expansive degree the conduct. The Section 53 of the Transfer of Property Act of 1882 disallows a person to convey or alienate his property when such conveyance defeats or delays the interest of his creditor or any subsequent transferee. Section 53 deals with the doctrine of fraudulent transfers. It provides that the transfer of immovable property made with the intent to defeat or delay the creditors of the transferor shall be voidable at the option of the creditor, so defeated and delayed with exception to the rights of a subsequent transferee, and has to be held in consonance with the Bankruptcy Code 2016. Section 53 deems transfers without consideration to be made with intent to defraud. This section deals with the transfer made to defeat or delay the creditors of the transferors, and that it is voidable at the option of such creditor. Any transfer of property in whatever manner done by or against a company 6 months prior to the commencement of winding up proceedings will be deemed to be a fraudulent preference and shall be deemed to be invalid. In the end, concealment of assets is such a commonplace form of bankruptcy fraud that it would also seem to be the type of fraud investigators should have best learned to root out and eliminate. All that an investigator needs to do is to find the hidden assets or find some form of financial statement that will prove that the assets are still existing, and the fraud will be proven. The basics of bankruptcy fraud are when people or organizations have more debts than they can manage, they sometimes file for bankruptcy. If filing for bankruptcy means creditors can no longer on their own try to sue or collect property to satisfy unpaid debts. Instead, creditors must go to the bankruptcy court where the application is filed, where the judge will determine how much property is available, how much is owed, and who gets repaid. The process is designed to allow debtors to have a new start by getting out from the crushing debts. When someone who has filed a bankruptcy or any other person conceals assets, makes a false statement under the penalty of perjury, orally or in writing, files a false claim, destroys or conceals financial records relevant to the case, or gives or takes a bribe, that person has committed a criminal bankruptcy fraud. A bankruptcy fraud can also be a civil wrong. The difference between a criminal and a civil fraud centers on the actor's intent. Criminal fraud requires proving that the defendant acted with a knowing and fraudulent intent, while a civil fraud involves less deception and cheating. A sham transfer. A sham transfer means a situation where the transferor does not intend that the property should really be vested in the transferee. Such transfers are therefore with the intent of non-operation between the parties. In one of the cases, the court held that the sale of property was made with a mutual consent of vendor and vendee with the intention to defraud the creditors of the vendor. There was no consideration, and the transferee also agreed to act as a benamidar until the transferor required him to reconvey the property to his sons. Transferor and his sons trespassed and occupied the property, as the creditors were defrauded. The transferor in defense urged that the transferee has no rights in the property as the transfer was a fraudulent transfer. Notwithstanding the rights of the transferor and the benami transferee, if the transfer was made to defeat the creditors, a creditor can proceed against the property, ignoring the benamidar as if the property belonged to the transferor. The creditor need not have to set it aside under this section because a benami transaction is not a transfer at all. For a transfer to be set aside, it has to be clearly evidenced that the very object of the transfer was to defeat the interest of the creditors. Fraudulent intention in transfers must be proved by direct or circumstantial evidence, and every case must be examined in the light of surrounding circumstances. Circumstances like when a transfer is made in secret and haste, or was made soon after a decree of debt ordering the payment of the debt, or where a whole property gets transferred without retaining any interest for the transferee, or where the consideration paid is so small as when compared to the real or the original value of the property transferred. Where there are several creditors and there is a transfer in favor of one to the detriment interest of the other creditors, this is liable to be set aside. Section 53(2) states that any gratuitous transfers of an immovable property with the intent to defraud a subsequent transferee shall be voidable at the option of the subsequent transferee. The burden of proof lies on the creditors of the transferor to show that the transfer was made with the intent to defeat or delay the creditor. The Bankruptcy Code provides a defense to the avoidance of fraudulent transfers. A transferee of a transfer that is voidable, that takes 1. for value, 2. in good faith, has a lien on or may retain any interest transferred to the extent of such transferee, gave value to the debtor. In exchange for such transfer, the creditor bears the burden of proving that it is entitled to the benefits. The Bankruptcy Code does not define the term good faith. Courts have determined good faith using an objective standard of what the transferee knew or should have known, and the transaction must carry the characteristics of being at arm's length. It is presumed that the transferee could not have acted in good faith if it had sufficient knowledge to place it on inquiry notice of the debtor's possible insolvency. In order to establish a good faith, the transferee must show an honest belief in the propriety of the activities in question, show no intent to take unconscionable advantage of others. 3. Show no intent or knowledge to the fact that activities in question will hinder, delay, or defraud others. Recovery of such transferred property. The recovery of such transferred property, if the transfer is avoided as a fraudulent transfer, the adjudicating authority can recover the property transferred for the benefit of all creditors, or obtain a judgment for the value of the property to be transferred from either the initial transferee or the person for whose benefit the transfer was made, or from a subsequent transferee. The Bankruptcy Code protects subsequent transferees that take the property subject to avoidance action for value and in good faith, and without knowledge that such transfer can be avoided. Furthermore, any immediate or mediate good faith transferee of such good faith transferee is also protected. To the extent that a good faith transferee, including an initial transferee, improves the value of the property after the receipt of the transfer, the good faith transferee is entitled to a lien for the cost after the deduction of profits of any improvements plus any increase in the value of the property on account of such improvements. Although the Bankruptcy Code empowers the adjudicating authority to sue the initial transferee and the immediate and the mediate transferees, adjudicating authority is only entitled to a single satisfaction of fraudulent transfer. As per Section 66 of the Bankruptcy Code, if during a corporate insolvency resolution process or a liquidation process, it is found that any business of the corporate debtor has been carried on with the intent to defraud creditors of the corporate debtor or for any fraudulent purpose, the adjudicating authority may, on the application of the resolution professional, pass an order that any person or persons who were knowingly parties to carrying on of the business in such a manner shall be liable to make such contributions to the assets of the corporate debtor as it may deem fit. On an application made by a resolution professional during the corporate insolvency resolution process, the adjudicating authority may by an order direct that a director or a partner of the corporate debtor, as the case may be, shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit. If before the insolvency commencement date such director or partner knew or ought to have known that there was no reasonable prospect of avoiding the commencement of a corporate insolvency resolution. In respect of such corporate debtor, and second, such director or partner did not exercise due diligence in minimizing the potential loss to the creditors of the corporate debtor. Offences and penalties with regard to bankruptcy fraud and punishments for such concealment of property. Where any officer of the corporate debtor has, within 12 months immediately preceding the insolvency commencement date, has willfully concealed any property or part of any such property of the corporate debtor, or concealed any debt due or from the corporate debtor of the value of 10,000 rupees or more, or fraudulently removed any part of the property of the corporate debtor of the value of 10,000 rupees or more, or willfully concealed, destroyed, mutilated, or falsified any book or paper affecting or relating to the property of the corporate debtor or its affairs, or willfully made any false entry in any book or paper affecting or relating to the property of the corporate debtor or its affairs, or fraudulently parted or altered or made any omission in any document affecting or relating to the property of the corporate debtor or its affairs, or willfully created any security interest over the transferred or disposed of any property of the corporate debtor which has been obtained on credit and has not been paid for unless such creation, transfer, or disposal was in the ordinary course of business of the corporate debtor, or willfully concealed the knowledge of the doing by the others of any of the acts mentioned in the clauses prior at any point of time after the commencement of insolvency date, has committed any of the acts mentioned, or has the knowledge of the doing by others of any of the things mentioned in the previous subclauses, or at any time after the insolvency commencement date, has taken in or pawned or pledged or otherwise received the property, knowing it to be so secured, transferred, or disposed, such officer shall be punishable with an imprisonment term which shall not be less than 3 years, but which may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both, provided that there is nothing in this section that shall render a person liable to any punishment under this section if he proves that he had no such intent to defraud or to conceal the state of affairs of the corporate debtor. Punishment for transactions defrauding creditors. On or after insolvency commencement date, if an officer of the corporate debtor or the corporate debtor has made or caused to be made any gift or transfer or change, or has caused or connived in the execution of a decree or order against the property of corporate debtor, has concealed or removed any part of the property of corporate debtor within 2 months before the date of any unsatisfied judgment, decree, or order for payment of money obtained against the corporate debtor, such officer of the corporate debtor or the corporate debtor, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years, or with fine which shall not be less than 1 lakh, but may extend to 1 crore, or with both, provided such a person shall not be punishable under this section if the acts mentioned in the clauses were committed more than 5 years before the commencement of insolvency date, or if he proves that at the time of commission of those acts he had no intent to defraud the creditors of the corporate debtor. Punishment for misconduct in the course of corporate insolvency resolution process. On or after the insolvency commencement date, where any officer of the corporate debtor does not disclose to the resolution professional all the details of property of the corporate debtor and the details of the transactions thereof, or any such other information as the resolution professional may require, or does not deliver to the resolution professional all or part of the property of the corporate debtor in his control or custody, and which he is required to deliver, or punishment for transactions of defrauding creditors, or does not deliver to the resolution professional all books and papers in his control or custody belonging to the corporate debtor and which he is required to deliver, or fails to inform the resolution professional the information in his knowledge that a debt has been falsely proved by any person during the corporate insolvency resolution process, or prevents the production of any book or paper affecting or relating to the property or the affairs of the corporate debtor, or the accounts for any part of the property of the corporate debtor by fictitious losses or expenses, or if he has so attempted at any meeting of the creditors of the corporate debtor within the 12 months immediately preceding the insolvency commencement date. He shall be punishable with an imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both, provided that nothing in this section shall render a person liable to any punishment under this section if he proves that he had no intention to do so in relation to the state of affairs of the corporate debtor. If an insolvency professional deliberately contravenes the provisions of this part of, he shall be punishable with an imprisonment for a term which may extend to 6 months, or with a fine which shall not be less than 1 lakh rupees, but may extend to 5 lakh rupees, or with both. Now, punishments for falsification of the books of the corporate debtor. On and after the insolvency commencement date, where any person destroys, mutilates, alters, or falsifies any books, papers, or securities, or makes or is in the knowledge of making of any such false or fraudulent entry in any register, books of account, of document belonging to the corporate debtor with the intent to defraud or deceive any person, he shall be punishable with a imprisonment term of not less than 3 years, but which may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. Now, punishment for willful and material omissions. Where an officer of the corporate debtor makes any material and willful omission in any statement relating to the affairs of the corporate debtor, he shall be punishable with an imprisonment term which shall not be less than 3 years, but which may extend to 5 years, or with a fine which shall not be less than 1 lakh, but may extend to 1 crore, or with both. Now, punishment for false representations to the creditors. Where any officer of the corporate debtor, on or after the commencement of insolvency, makes a false representation or commits any fraud for the purposes of obtaining the consent of the creditors, the corporate debtor, or any of them to an agreement with reference to the affairs of the corporate debtor during the corporate insolvency resolution process or the liquidation process, or to the priority just prior to the commencement of insolvency date, has made any false representation or has committed any fraud for that purpose, shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend up to 5 years, or with a fine which shall not be less than 1 lakh rupees, but which may extend up to 1 crore rupees, or with both. Now, punishment for contravention of the moratorium. Where the corporate debtor or any of its officer violates the provisions of section 14, any such officer who knowingly or willfully committed or authorized or permitted such contravention shall be punishable with an imprisonment for a term which shall be not less than 3 years but may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees but may extend to 3 lakh rupees, or with both. Where any creditor violates the provisions of section 14, any person knowingly and wilfully authorizing or permitting such contravention by a creditor shall be punishable with an imprisonment for a term which shall not be less than 1 year but may extend to 5 years, and with a fine which shall not be less than 1 lakh but may be extended to 1 crore, or with both. Where the corporate debtor or any of its officers or creditors or any person whom the approved resolution plan is binding on under section 31 knowingly and wilfully contravenes any of the terms of the resolution plan or abets such contravention, such corporate debtor, officer, creditor, or person shall be punishable with an imprisonment of not less than 1 year, but which may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees, or with both. Now, punishment for false information being furnished in application form. Where any person furnishes information in the application made under section 7 which is false in material particulars, knowing it to be false, or omits any material fact knowing it to be material, such person shall be punishable with fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Now, punishment for non-disclosures of dispute or repayment, where an operational creditor has willfully or knowingly concealed in an application under section 9 the fact that the corporate debtor had notified him of a dispute in respect of the unpaid operational debt, or the full and final repayment of the unpaid operational debt, or any person who knowingly and willfully authorized or permitted such concealment under clause, such operational creditor or the person as the case may be shall be punishable with an imprisonment term which shall not be less than 1 year but may extend to 5 years, or with both. A fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Now, punishment for providing false information. Where a corporate debtor provides information in the application under section 10 which is false in material particulars, knowing it to be false, and omits any material fact knowing it to be material, or any person who knowingly and willfully is authorized or permitted the furnishing of such information under such subclauses, such corporate debtor or the person as the case may be, information under the previous subclauses, such corporate debtor or person as the case may be shall be punishable with an imprisonment for a term which shall not be less than 3 years but which may extend to 5 years, or with a fine which shall not be less than 1 lakh rupees but which may extend to 1 crore rupees, or with both. So, these are some of the penalties and punishments with regard to bankruptcy fraud. Thank you so very much.